Hello, I'm attorney Morris E. Fisher, and I welcome you to our YouTube channel, and I invite you to become a subscriber. As more people are now heading back into the office for work, the COVID era is kind of done. It is a good opportunity to review some of the fundamentals of sexual harassment. And during the COVID era, a lot of meetings were on Zoom and such. It's not impossible to sexually harass someone on Zoom, but it's mighty hard to have a case. Certainly, there's no touching or anything like that. The parties are physically separated, but that kind of is now ending. And some new tricks that employers are using here to shut down sexual harassment claims. We are handling a case right now. It's against the U.S. Department of the Army, and it's an ongoing litigation. I can't get into the names of anyone or anything like that or confidential information, but it does involve a sexual harassment claim. So the first issue that I noticed in some of these claims has to do with the initial filing deadline. And just to review, employees in private sectors have 180 days in some states to file with the EEOC. In other states, it's 300. If you miss the 180 days or the 300 days, you have missed the statute of limitations and your case cannot proceed. For federal employees, they have 45 days not to go to the EEOC, but to go to the Office of Civil Rights, otherwise known as the EEO office, at the branch of their federal agency. So what some employers are doing is they are creating these groups, such as, I don't know, the conflict resolution group, where when you have a complaint about a manager, no matter what that complaint is, we're going to take you and we're going to recommend you go to this conflict resolution group. The Army, by the way, has this SHARP unit, stands for Sexual Harassment, Assault Response and Prevention Program. So it's really interesting because if you take a look at the Army's SHARP page on their website, and it looks really benign and benevolent and helpful. This is what we're trying to do. We're trying to protect the victim, increase training, so on and so forth. They define what sexual harassment is. They tell you about the Inspector General's office, and it all looks really wonderful. What you'll notice on this page is nowhere on this page does it say, by taking your case to the SHARP, you have met the 45-day deadline. And what do you think happens? People go to the SHARP, they don't meet the 45-day deadline, and bam, you're going to get an argument that your case loses on limitations because you didn't file with the EEO within 45 days. That's key. Number two, the manager summary. This is what I love. Usually it's by email. So what happens is a sexual harassment victim is going to complain to a supervisor or a manager about, let's say, inappropriate touching by a coworker. And what this supervisor or manager may do is write a summary of your complaint and couch it in any way other than sexual harassment. This is something like, you contended that your coworker or your first line supervisor was overly harsh and aggressive towards you, so on and so forth. No, that's not the complaint. The complaint that I had was he was sexually harassing me, and I'd like to see that in your summary. Now, you have to ask yourself, why would the supervisor or manager not write the words complaint about sexual harassment? Why not? Well, we know that knowledge of sexual harassment by the employer is an essential element in a sexual harassment hostile work environment claim. So if the employer can say, listen, there's nothing ever in any of my notes that referenced sexual harassment specifically, and you didn't put in writing the complaint of sexual harassment specifically, or something related to it, like inappropriate touching or fondling or something like that, or asking me out on a number of dates that I made it clear to my manager I wasn't interested. If you didn't do that, we don't have knowledge of it, and therefore we're not liable. Okay, now it's interesting because in the case I have, there was one of these emails. It did exactly that, but then it says, you know what we're going to do about this? We're going to have a mediation about this. And guess who did the mediation? Let's try the EEO office. Why would they do a mediation about something that's not sexual harassment? In fact, that would be something to send to the conflict resolution group or the SHARP. Why would they do it? It has to be because the complaint, the preponderance of evidence is the complaint really was about sexual harassment. That's another key. Third thing I've noticed in some of these cases is that when the agency finally does an investigation, it's not about sexual harassment. It's either about a hostile work environment. And when I say investigation, I'm not talking about the traditional EEO report of investigation that takes 180 days. I'm talking about some of these agencies or some of these employers in the private sector even bring in a big law firm to do the investigation. Was there sexual harassment? Was there a hostile work environment? The one I noticed in the case that I have is that there was no sexual harassment investigation. There was a sexual assault investigation, but not sexual harassment. In fact, the supervisor says in her affidavit, she says, I take all allegations of sexual harassment extremely seriously. But it doesn't say including or especially sexual harassment. I mean, now let's think about this for a minute, about this defense. Okay, the employer says what you suffered was sexual assault, not sexual harassment. Okay, so in a case where someone, heaven forbid, is raped 3 or 4 times by a manager, what's the defense? That wasn't sexual harassment? That's only sexual assault? That's insane. It's a defense. Got to look out for it. What do all of these points have in common? Here's what it is. It all looks to the outsider, to a fact finder, to a judge, to a juror, that the employer really cared about stopping sexual harassment and that the employer did all the right steps to stop it. But what really happened in each of these 3 instances? Well, in the first example, the employer attempted to create a situation where the employee could miss the deadline. In the second example, the employer cared about solving a problem, but not a sexual harassment problem. And the third example is even more egregious. There, it looks like the employer is trying to solve a problem that's even greater than sexual harassment. The employer is trying to solve a sexual assault problem. All of these are diversions, and they're attempts to ruin your sexual harassment case. If you have been a victim of sexual harassment, we can help. Call our office. It's what we do. And we also invite you to subscribe to our YouTube channel.